Good afternoon, everyone. Welcome to our webinar today. It looks like it's straight up 12 o'clock, so we will go ahead and get started. First up, my name is Lisa Carlson, and I am an attorney at Holland & Hart in the Health Law Group, and I am based out of the Boise office. And later on, I will have another one of our attorneys joining us. His name is Jay DeVoy, and he is based out of the Las Vegas office. So today we're going to talk about the discharge planning requirements that came out in the final rule that was published by the Department of Health and Human Services and the Centers for Medicare and Medicaid Services on September 26th. So of course, because this is a legal presentation, there's a little disclaimer that says this is for educational purposes only, and if you have any substantive questions, contact your legal counsel. As far as what we're going to talk about today, first, going to briefly talk about the main objectives that CMS is hoping to accomplish by implementing this rule. Then we'll talk about the minor change to patient rights in the conditions of participation that applies specifically to hospitals only. Then we'll get into the discharge planning rules that apply to hospitals and critical access hospitals. I'll point out the differences between the new rules and the ones that were already in place. Then Jay is going to take over and talk about discharge planning rules that apply to home health agencies. And finally, he will talk about some other considerations that you'll need to stay mindful of when carrying out the new requirements. Hospitals specifically need to accept along the way. You may have questions, which is fantastic. All questions are welcome. There's a feature within WebEx. You can either use the chat function or even better, the Q&A. And if we have time, we will answer your questions in the webinar, or we will follow up with you directly after the webinar. Also, you're welcome to email either Jay or me at the addresses that you can see on your screen. All right, let's get started. So first of all, the objectives. When the final rule was published in September, the CMS administrator issued the following statement, which is a great summary of their current objectives, and that's to improve operability between patients and healthcare providers. So Seema Verma says, today's rule is a huge step to providing patients with the ability to make healthcare decisions that are right for them and gives them transparency into what used to be an opaque and confusing process. By demystifying the discharge planning process, we are improving care coordination and making the system work better for patients. Patients will now no longer be an afterthought. They'll be in the driver's seat, playing an active role in their care transitions to ensure seamless coordination of care. In the final rule itself, it listed two other objectives, which is actually, it's more than two objectives. It's a lot of objectives, but kind of consolidated into two main points. First, it says the final rule empowers patients to be active participants in the discharge planning process and complements efforts around interoperability that focus on the seamless exchange of patient information. It also implements discharge planning requirements that will give patients and their families access to information to help them make informed decisions about their post-acute care, while addressing goals of care and treatment preferences, which may ultimately reduce chances of being rehospitalized. So I've distilled it down into the following objectives. Patient participation. CMS wants patients to be empowered to participate in the discharge planning process. They want informed decisions, want hospitals, home health agencies, critical access hospitals to give patients access to information about the care options that are available to them so that they can make informed decisions about their post-acute care providers. Also, the process needs to be patient-focused. All discharge planning should be focused on patient goals and treatment preferences. And finally, information exchange. The objective is to improve the information exchange between healthcare settings. The ultimate goal is to reduce the incidence of rehospitalizations of patients. So as far as who this rule applies to, it impacts all types of hospitals, and I've listed the various types below. It It applies to critical access hospitals, and then specific to post-acute care settings, it applies to home health agencies. And then, of course, the timeline. The commenters specifically considered whether how much time was necessary and whether more than 60 days was needed to be able to implement the rules when the final rule came out, and they said unequivocally no, 60 days is plenty. So this final rule goes into effect on November 29th of this year, so just around the corner. All right, so getting right into the new requirements. So this patient rights change affects only hospitals. And you'll see in the red font, I've noted the change from the previous rule to the red font now is the addition, the amendment. So a patient has the right to access their medical records, including current medical records, upon an oral or written request in the form and format requested by that individual if it is readily producible in such form and format, or if not, in a readable hard copy or in other form as agreed to by the facility and the individual within a reasonable time frame. What that means? That means that now when patients request either in an oral or written format, they're entitled to their current medical records in the form that they want. If the facility cannot comply, you cannot provide them with those records in the format that they want, facilities are expected to communicate with patients to come up with an agreeable format that the facility can comply with and that will make the patient happy. One thing that's to be noted is that if the patient doesn't have a preference, then it's up to the hospital to decide what the form and format will be as far as providing those records. And again, it's to include all current medical records. So anything that's available to the facility at that time needs to be provided to the patient according to their request. And finally, they left a provision in there that says the hospital must not frustrate the legitimate efforts of individuals to gain access to their medical records and must actively seek to meet these requirements as quickly as its record-keeping system permits. So as far as timing, everyone already knows under HIPAA, a covered entity generally has 30 days to respond to requests for records. The commentary to this rule recognizes that with advancements in technology, covered entities typically can comply much quicker than 30 days. So while it doesn't supersede HIPAA and the 30-day requirement, it certainly suggests that facilities need to comply with these requests as quickly as possible. So the key takeaways, covered entities, hospitals specifically need to accept verbal and written requests by the hospital for their records, include the discharge planning documents and other current records available, communicate with the patients to determine their preferred format, or if they don't have a preference, hospital can have the flexibility to decide, and beware some state laws may impose stricter requirements. So I did hear that my voice, I do see a Q&A that my voice is cutting in and out. I hope you are able to hear me better. I've moved the mic closer to my mouth, but let me know if that is not, if that's not helping, and I can certainly make a switch. Okay, moving on. Okay, thank you for clarifying. Says that another person says they're not experiencing voice issues. So let me know if there continues to be a problem, and I will switch to my handheld. Okay, so as far as the discharge planning requirements, we've broken it down into hospitals and critical access hospitals, and then home health agencies. So as far as the hospitals and critical access hospitals, when I say hospital, I am including critical access hospitals just so I don't have to say that mouthful every single time. If there's a regulation that doesn't apply to a critical access hospital, I will specifically call that out. But for the most part, the regulations are parallel. They track almost verbatim. So I've broken down the discharge planning rules into those that were first promulgated as part of the Impact Act, and those that are revisions to the improvements or improvements to the existing hospital discharge planning conditions of participation. So for those of you who may not know or remember the IMPACT Act, it dates back to about 2014, and it stands for Improving Medicare Post-Acute Care Transformation. The goal of this act was essentially to standardize post-acute assessment data in order to give patients access to that information to help them make more informed decisions about when selecting their post-acute care providers. The additions found here at my citations are at the bottom, 42 CFR 482, 40.43, subsection 8 for hospitals, and then the second section is for the critical access hospitals, 485, 642, 88 also, requires facilities to assist patients in selecting a post-acute care provider by sharing data that includes home health agencies, skilled nursing facilities, inpatient rehab facilities, and long-term care hospital data on quality measures and data on resource use measures in order to help the patient make those informed decisions. The expectation here is that the hospital is responsible for ensuring the patient receives relevant information that's applicable to their goals of care and treatment preferences. So it's very patient-centered, very individual-specific information that they should be receiving from the hospitals. The takeaways from this, it's pretty straightforward. It's basically that the hospitals need to be available to discuss and answer questions from their patients, and caregivers about the post-discharge options. Hospitals need to document in the medical record that this data on quality and resource use measures were shared with the patient and how they were used to assist the patient during the discharge planning process. And, you know, to that point, sometimes there's patients who don't want assistance and don't want the information, and providers are expected to document that, you know, any efforts that they made and the patient's refusal in the medical record as well. Third point is to use reasonable efforts to provide information that's currently available. So the commenter specifically pointed out the care comparison websites that are currently available. And those are actually included within the slide deck later on in the presentation near the end for your reference. But the final rule indicates that more data sources will be forthcoming, but that the expectation is for providers to use what is currently available to them. They don't have to give overly detailed or complex analyses of the data, but just put forth their best efforts to answer questions. The commenters also considered whether providers should have to investigate and share whether a particular post-acute care provider is covered by a patient's insurance, and they stated, well, that would be fantastic. It's not a requirement. And certainly they were trying to remain mindful of the burden that that would cause for providers. And then fourth, avoid claims of patient steering. So obviously that's always something that's at the forefront of folks' mind when discharging someone to a facility, especially if it's a facility that is financially affiliated with the hospital. So the commenter specifically stated that in order to avoid claims, obviously you still need to remain mindful and focused on compliance with STARC and anti-kickback. But if you're presenting evidence that is or objective data that is specific to the patient's goals of care, and you're presenting all of the post-acute care providers that are available to the patient, you're allowing and encouraging patient choice, and you're documenting all of your efforts in the record, you will be in a much better position to avoid those claims of inappropriate patient steering. For the remainder of the discharge planning conditions that are specific to hospitals, both critical access and regular hospitals, I thought it would be easiest to do a side-by-side comparison of the new rules and the old hospital rules. So the font in red, of course, is that which is newly added. And on the right-hand side of this slide, you'll see the old rules, which were found at 482, 43 for hospitals, and then the new rules are found in the citations above 482, 43 for hospitals, and 485, 642 for critical access hospitals. So in this first row, it specifically calls out those objectives that I discussed at the beginning. The objective being to focus on the patient's goals and treatment preferences, to include the patient and their caregiver, if necessary or if the patient approves, as active partners in the discharge planning, and then ensure that the discharge planning process is consistent with the patient's goals for care and treatment preferences, and finally to ensure an effective transition of the patient from the hospital to post-discharge care. Again, that ultimate goal at the end is reduced to writing, to reduce the factors leading to preventable hospital readmission. So as you can see, the previous rule was very sparse, have in effect a discharge planning process that applies to all patients. And I'm going to back up for a minute just to specifically call out the commenter's contemplation of the burden that these new rules would impose on both regular hospitals and critical access hospitals. They specifically contemplated that the imposition of the new discharge planning rules would not actually create much burden because they felt that both types of hospitals were already engaged in this type of planning practice. And so it was really just a formal codification of those expectations and those processes that were already in place, maybe more informally. I didn't specifically reference the code provisions or the rule provisions that for the critical access hospitals that the commenters were referencing, because they were kind of scattered all over the place as far as what they were relying on to say that critical access hospitals were already doing all of these things. But certainly they didn't feel like that there was going to be a large burden in implementing these new rules. Okay, so moving on to the second row, the hospital discharge process must identify at an early stage of hospitalization those patients who are likely to suffer adverse health consequences upon discharge in the absence of adequate discharge planning. So here, when they say identify at an early stage of hospitalization, what they're suggesting is that this early stage is ideally when that patient is first admitted as an inpatient or shortly thereafter. So they're talking about being able to identify patients that could benefit from discharge planning due to potential adverse health consequences really early on based upon their presenting conditions. And in this final row, the requirement is obviously that for those patients that the hospital identifies as likely to suffer an adverse health consequence, that the hospital provide a discharge planning evaluation for those patients. Additionally, the hospital is expected to provide discharge planning evaluations for other patients if they request it, or if their physician requests that evaluation. So moving on, in row 1, it states that any discharge planning evaluation must be made on a timely basis to ensure that appropriate arrangements for post-hospital care will be made before discharge and to avoid unnecessary delays in discharge. This one is very similar. Like you can see, there's no red font, there's no real substantive difference in this requirement, so it's pretty straightforward. You don't want to impose delays on discharge. In row 2, this subsection, A2, clarifies and expands the requirements of the evaluation, requiring it to cover the patient's need for appropriate post-hospital services to also include hospice, post-hospital extended care services, home health services, and non-health care services and community-based care providers. It also requires at the bottom that you include a determination of the availability of the appropriate services, which is an old requirement, but also the patient's access to those services. There's a lot of unwritten expectations that goes along with this particular rule. So when the rule is referencing non-healthcare services and community health or community-based care organizations, the expectation is that providers will develop collaborative partnerships with those organizations in their respective areas to improve patient transitions of care. These community-based organizations are in a unique position to be able to provide the support that can improve patient outcomes. So, and if you don't know what I'm talking about when I say community organizations, they're contemplating specifically aging and disability resource centers, area agencies on aging, and centers for independent living. So their expectation is that hospitals will know about these community-based resources, know which ones are available, be able to connect the patients with those resources, and of course, document any efforts in the record of these efforts. On the final line, the discharge planning evaluation must be included in the patient's medical record for use in establishing an appropriate discharge plan, and the results of the evaluation must be discussed with the patient or the patient's representative. So again, if the patient refuses to participate or doesn't want the information, document that as well. So section A4, you'll see there's not a lot of red font on this page, means there's not a lot of substantive changes, but I'll go through the rules anyway, just for clarification of what these requirements are. So A4 states, requires the discharge plan to be implemented by the hospital upon the request of the patient's physician. A5 requires that the discharge plan is developed by or under the supervision of a registered nurse, social worker, or other qualified personnel. So on this particular provision, there's some flexibility here, especially for critical access hospitals. Commenters specifically contemplated that critical access hospitals are able to utilize telehealth services to effectuate this requirement. And there's also some built-in flexibility as far as the hospital's determination of who is an appropriately qualified personnel under this rule. And then finally, in section A6, the hospital's discharge planning process must require regular reevaluation of the patient's condition to identify changes that require modifications to the discharge plan. And then, of course, the discharge plan will need to be updated to reflect any changes. So that one's pretty straightforward. As far as all of the red on this page. So A7 requires hospitals to assess their discharge planning process on a regular basis to ensure that the plans are responsive to patient post-discharge needs. So this changes the previous provision to add a specific requirement that the review include patients who were readmitted within 30 days of a previous admission. Commentary suggests that while there's no prescribed time frame for reassessing its discharge planning, so what is regular basis, there was a very strong recommendation that hospitals do so every 2 years at a minimum. And then there was even more recommendation that hospitals are encouraged to consider this more frequently and also to consider performance metrics when reassessing the discharge planning process. On row 2, this is just where the Impact Act requirements of providing patients with information about post-acute care providers, that's where this lives, so I'm not going to go over that again. And then finally, in subsection B, it adds the requirement that hospitals transfer or refer the patient along with all necessary medical information pertaining to the patient's current course of illness and treatment, post-discharge goals of care and treatment preferences at the time of discharge to the appropriate post-discharge or post-acute care service providers that are going to be responsible for the patient's follow-up care. So specific to this provision, the final rule is intended to give providers flexibility in what they deem to be necessary medical information. So that can include information such as food and drug interactions or food limitations, nutritional needs of the patient. Certainly anything that's clinically relevant should be included. And the commenters even went so far as to suggest that current diagnoses, behavioral health issues, lab results, and patient functional status would qualify as necessary information. Additionally, facilities that are capturing electronic information should really be sharing that information electronically with those post-acute care providers that have the capability to receive records electronically. There's a lot of comments about the advancements of technology and EHR, electronic health record platforms, and coming changes. They'll be contemplated in other rules. So to the extent that that it's being contemplated, it was certainly implemented in this rule through just the facilitation of sharing information from one facility to the next. There's also some commentary in the final rule suggesting that they will be providing additional guidance about what type of information is required to be included in a transfer summary to avoid any unnecessary delays in discharge or transfer. So, for example, in a routine transfer, what needs to be included as opposed to an emergency transfer. So that guidance will be forthcoming. And additionally, the guidance did suggest that you should not delay transferring records or information to a post-acute care provider just because a particular document is not signed by the appropriate provider. It suggests sending interim information and then following that up once you're able to obtain all of the necessary signatures at that time with a more formal finalized document. So the final two slides are sections that only apply to hospitals. So critical access hospitals, you can tune me out for the next couple slides. So you'll notice at the top the comments that say, for those patients discharged home and referred to home health agency services or transferred to a skilled nursing facility or an inpatient rehab facility or a long-term care hospital, the following requirements will apply. So these are the old requirements as far as providing a list of facilities available with the discharge plan. What you'll see included is that now hospitals are required to include in their discharge plan list inpatient rehab facilities and long-term care hospitals that are available to the patient participating in Medicare and that serve the geographic area or that are in the geographic area requested by the patient. Pretty straightforward as far as the requirements are the same as they've always been. It needs to be part of the evaluation, discharge evaluation process. One of the other changes you'll see in subsection 2 there that patients, the hospitals must make patients aware of the need to verify with their managed care organization which post-acute care providers or suppliers are in the managed care organization in their network. So if the hospital has information on which practitioners are included in that network, they are required to share that information with the patient or the patient's representative. Commentary suggests that hospitals are encouraged to work with post-acute care providers to develop a system for identifying which ones are in network, but certainly aren't required to affirmatively know all of the answers, just certainly to assist in that process and share any information that they definitely know. And then finally, there's, of course, document that the list is presented to the patient or the patient's representative. So currently, CMS does put together a list of skilled nursing facilities and home health agencies. The comments suggest that hospitals will be responsible for putting together their own list of inpatient rehab facilities and long-term care hospitals that are available in the geographic region that are available to their facility. And finally, hospitals must inform patients of the right to choose among providers and suppliers, respect the patient's goals of care and treatment preferences, or any other preferences they express. So the discharge plan, and of course the most important, number 3, don't forget, we must also include any financial interest that the hospital has in the home health agency or the skilled nursing facility and financial interest. Again, there's no additional commentary regarding how to disclose that. You can either keep a separate list of facilities that the hospital has a financial interest in, or you can highlight it. There's no express requirements as far as how you call attention to that disclosable financial interest. So the key takeaways here for hospitals and critical access hospitals is to maintain policies and procedures for post-acute care planning, ensure that the discharge planning process focuses on the patient's goals and treatment preferences, includes the patient and caregiver as an active participant, and to ensure that the discharge plan is consistent with the patient's goals and treatment preferences, provides an effective transition to post-discharge care, and reduces factors leading to preventable hospital readmission. So hospitals are expected to provide all necessary medical information to the accepting facility, including the goals and treatment preferences, to ensure that continuity of care. And then hospitals specifically add your inpatient rehab facilities and long-term care hospitals to your list of facilities that are provided with your discharge plan. And with that, I will turn the time over to Jay to discuss home health agencies.
Greetings. Hi, everybody. I'm just here to fill in on the home health agencies part of it. Lisa, thank you for your presentation. It's extremely informative. Now, home health agencies face a slightly different set of changes in circumstances under the Impact Act in the most recent round of rulemaking. Now, home health agencies already were subject to a number of these kind of requirements for discharge planning and having a plan for transition of care, but they're codified in a slightly different way now under the Impact Act, and there was the addition of a new rule that imposed new obligations on home health agencies to ensure that the kind of quality measures the quality measures and the resource use measures that were gathered from long-term care hospitals, skilled nursing facilities, and inpatient rehabilitation facilities that were gathered by CMS under the Impact Act were reported to patients and their caregivers when they're being discharged from an HHA or transferred to another HHA. So to go over what the goal of the impact was with respect to the HHAs, we have this slide that summarizes what the goal of the HHA changes were under the newly promulgated rule, which can be found at Title 42 of the Code of Federal Regulations, Section 4458. So the goal of the Impact Act was to use the information that's being gathered and reported to CMS by these post-acute care facilities and services in order to gather data, and now the home health agency needs to share it with patients who are being discharged or who are being transferred, including data about other home health agencies, in order so the patient and the caregiver can make more informed choices about the post-acute care setting. Now, all of the information needs to be transferred, similar to the new rule that was adopted for hospitals, includes all necessary medical information. And the additional obligation under home health agencies is that they need to comply with future requests from the new post-acute care setting that the patient is discharged to. Now, what's important about that is that there might be information that the home health agency keeps within the scope of its clinical records, which already need to exist under other existing regulations, and that go a bit beyond what normal medical records or other medical information would be, although the commentary from CMS with the proposed rule indicates that it treats medical information and clinical information that's kept under the pre-existing rules for home health agencies interchangeably, and it uses the same term to identify both in the commentary that it provided. So there's a wider swath of information that home health agencies are already required to maintain, and they have obligations to maintain it for a period of several years. And now there's the obligation to provide it to these new post-acute care facilities and services upon request from them, not necessarily from the patient under the new rule, although they may be obligated to provide that information under HIPAA. But there is a new obligation for the home health agency to provide it to the successor post-acute care provider. So the key takeaways for HHAs are that they need to present objective data on quality and resource use measures for other post-acute care services or facilities to which the patient will be discharged or transferred, and to include all of the data that's available at all of the post-acute care providers to which the patient might be transferred or discharged. The goal isn't as comprehensive as quite the hospitals in terms of an interactive process, although that's what the commentary contemplates, about making sure that patients and caregivers are involved in the process of understanding what treatment options are available to them and select the one that is right for them. Now, in addition to that, this new rule adds some additional obligations for home health agencies, but a lot of what's covered in this, similar to the changes that Lisa was discussing, there are pre-existing rules that this new rule integrates into, and it expands on the obligations that are imposed upon home health agencies, but it's just extending what is required and adding more detail to the information that has to be provided, rather than thinking of it as a whole new requirement that didn't exist previously. So as noted, there's one new rule. It's not an amendment to an existing rule the way that the changes were to the critical access hospitals and to the hospitals. The new rule that is created based on this rulemaking, as I noted earlier, is found at 42 CFR section 4458. It's relatively small. It has two pieces to it, but it integrates with existing rules which are referenced below, and those include 44 subparts 50, 55, and 110, and also is referenced in the commentary, although to a slightly lesser degree, subpart 44, part 60 is relevant as well in terms of the obligations that already exist for these home health agencies and how they fit together with subpart 58 that's been created by this new rulemaking. So the new rule, section 44.58, that is a new condition of participation in Medicare for home health agencies. It's going to be evaluated and measured by state surveying agencies or other accreditation agencies, and it's going to help, well, the point of it is to help with patients and caregivers transition away from home health agencies, whether to discharge or for transition to another home health agency. Now, as noted, this was previously required in some form with a discharge summary, but in terms of the information that needs to be included, specifically about quality care measures and for resource use measures, that's new and covered by 44.58. So this is, as noted, additional detail that wasn't present before. It may have been something the home health agencies were providing, but now you have this mandate from CMS about the information that needs to be provided and the form and format in which it needs to be provided to patients and their caregivers. So there's two, as noted before, there's two subparts to the proposed rule. Now, what's interesting about this rule isn't so much what was integrated into the final rule, but the commentary that came from CMS in the process of making this new rule, and it started back in 2015 and 2016 when CMS first began soliciting comments about proposed rules, is that subpart A of 44.58 was supposed to originally have 7 different components. Now, CMS ultimately concluded that all of those obligations were overly burdensome on the home health agencies, and the section that was proposed as 44.58A6 is ultimately what was adopted, and that is the totality of subpart A. But there is a lot of record now at this point in the rulemaking dialogue that happened within the Federal Register, which I'm sure is available in the resources that we've previously distributed. And if you don't have it, please feel free to contact Lisa and I. We'll be happy to provide it to you. But it indicates a lot of other obligations that CMS contemplates and almost passed in the form of adopting this final rule for additional records that home health agencies were required to provide and additional detail that home health agencies were almost going to be required to provide at the time of discharge in terms of the patient's diet, smoking status, and other things of that nature, similar to what Lisa was describing earlier about information that can be provided at the time of discharge that falls in the broader envelope of medical information beyond just healthcare records and electronic healthcare records. So the exact language of the subparts of the new rule is set forth in the following two slides. New rule section 44.58 sub A indicates that the HHA has to develop and implement an effective discharge planning process. And I think the lever for enforcement of this section in the future will be what constitutes an effective discharge planning process, and any kind of botched handoffs or problems with transitioning a patient out of the HHA context will be a basis for potential statements of deficiencies or other action based on whether or not the discharge process is going to be effective. Now, what this rule prescribes in that regard is just the sharing of information about skilled nursing facilities, intermediate rehabilitation facilities, and long-term care hospitals, as well as other home health agencies, and providing that information that was discussed with the hospitals and the critical access hospitals with respect to the quality measures and the resource use measures. That information needs to be provided, and it needs to be shared about all of the other entities that could be a potential final place of discharge or transfer for the patient. So the HHA also must ensure that the post-acute care data on quality measures and data on resource use measures is relevant and applicable to the patient's goals of care and treatment preferences. So to the extent that patients have specific needs for treatment and some facilities are responsive to them and others aren't, whether there's need for specialty care, if there's special circumstances that are present in the patient's condition that can be addressed by certain post-acute care facilities or services, such as if there's a long-term care hospital that's particularly responsive to a need that the patient has versus a skilled nursing facility that might not be so relevant. That information needs to be provided to the patient and the caregiver so that they can engage in selecting the proper post-acute care treatment for themselves. In the next slide, it covers the remaining sections subpart B1 and B2, that are integrated into this new rule. So the discharge or transfer summary content, this specifies the information that is ultimately going to be required. And again, this is a pared down version of what was originally proposed and discussed within the Federal Register. And there's information within that commentary about where CMS was looking in terms of what they might be doing in the future and what obligations were contemplated for this round of rulemaking in terms of the information that would have been included within this summary. This would have included information about advanced directives, course of illness, past procedures and diagnoses, which would be present within medical records, but other information that would have been relevant to the patient's goals about treatment, and other information such as dietary information and information about upcoming healthcare-related appointments, and any other needs such as the patient's medications and anticipated needs even for durable medical equipment. So what ultimately was passed in the final rule is a scaled-down version of that. What is defined, again, as necessary medical information might be a point of inflection in the case of complaints or there being problems that are reported to a state survey agency or to CMS directly, and that might be a point where there's enforcement action or, again, statements of deficiency that are issued based on patient experience and what they ultimately receive from the care that is provided from the HHA during that critical point of transition or discharge, whether to another HHA or to one of the other facilities we've been discussing. So making sure that that information, whatever the patient ultimately deems to be necessary medical information or the successor facility deems to be necessary medical information, will be important for complying with this rule. Now, fortunately, there's a measure in the next section of this, which is subpart B2, where the HHA has to comply with requests for additional clinical information from successor entities. And I think that might make it a lot easier to avoid any kind of problems with complying with subsection B1, in the sense that any subsequent post-acute care facilities or services can request this information, and it will be easier for the HHA to comply with providing the necessary medical information based on these follow-up requests not only that are permitted and contemplated under the rule, but under which the HHA is required to provide that additional information. So I think that will make things easier from an HHA standpoint, and it will reduce their obligation, well, it will reduce their burden of compliance. It won't necessarily reduce their obligations, but it will make them easier to satisfy and to make sure that they provide the information that is deemed necessary medical information, even just beyond normal healthcare records and the records that are already required to be maintained and provided at the time of discharge under existing rules and regulations. So the key takeaways from this new condition of participation is that the HHA has to develop and implement a effective, and I put special attention on what is an effective discharge planning process, because ultimately if there are going to be negative patient outcomes and potential claims or complaints to state survey agencies, the question of its efficacy is going to become an issue for the HHA, and it will potentially be fined and subject to other sanctions up to and including potential administrative action in front of CMS until CMS determines and deems that it has what is an effective discharge process. The other information that the HHA needs to provide should ideally go beyond just the quality measures that are required to be reported under the Impact Act and are gathered from other facilities pursuant to that law. But at bare minimum, the quality measures and the resource use measures need to be provided for skilled nursing facilities, for IRFs, and for long-term care hospitals, as well as other HHAs, depending on where the patient is going to be discharged, and to help the patient and the caregivers make an effective plan for either discharge into a different post-acute care setting or transfer to a different HHA. And then this information needs to comply with the other requirements that already exist, specifically under Parts 44.60 and 44.110, that require the HHA to provide information at the time of discharge and maintain certain information and communicate any changes in information to the patient and the caregiver at the time of discharge and even after the fact, depending on changes that might occur up to the point of discharge in the patient's care plan. Now, finally, this new change requires the HHA to provide all necessary medical information to the accepting facility, whether it's being discharged, whether the patient is being discharged to a different post-acute care facility, such as a skilled nursing facility or a long-term care hospital, and ensuring that all of the medically necessary information that the recipient of the patient will need is provided, and also following up on those requests. And that includes in cases where the HHA transfers the patient to a different HHA, whether because of a patient request or because of different skills and services that are offered by a different HHA. And there's some other considerations as well with regard to both hospitals and critical access hospitals, as well as HHAs, about making these transfers and these discharges and the planning that goes along with them and the disclosures that need to be made. Lisa had some points that she wanted to make specifically about referrals, and then I will speak about the HIPAA and other issues that come up that we had discussed previously, and we wanted to make sure everyone is aware of and apprised of that could happen in terms of avoiding situations where there's unapproved remuneration for a transfer or referral, or an impermissible transfer to another entity in which the transferor or discharging entity has a financial interest. Lisa, do you want to take that over quickly?
Sure, yeah. So it's basically just a recap of what I discussed earlier, that when you're providing that discharge list to patients, you want to make sure that you're disclosing appropriately as is required in the regulation, and it has a definition of what constitutes a financial interest that you'll want to remain mindful of, and that you're disclosing that in the discharge summary list that you're providing to those patients. And then, of course, remaining mindful of compliance with your Stark and anti-kickback regulations as far as not accepting improper remuneration for those referrals. As far as transfer concerns, I think again, I did briefly touch on the transfer concerns as far as medical records and not delaying the appropriate transfer of care. Especially if there is an emergency medical situation, you have concerns under EMTALA. So certainly the CMS commenters did not want folks to get too hung up on the issues with what documentation should we be providing. Certainly patient care comes first. It's I think the mantra of CMS is now patients over paperwork, which I thought was quite catchy. So that's certainly a goal and objective of CMS. So that is all I have to add there. Jay, are you still with us?
Yes, I am. Am I on?
Yes.
Okay. Sorry, I didn't see the transfer prompt. So the other concern that comes up with transfers, and I think, Lisa, you might have talked about this earlier with respect to making medical records available within the hospital context. It's a lot easier, and there's that new change to the rules that allows for consideration of making sure that records are available to the patient upon their request. And that aligns very closely with what's allowed already for the request for individuals for individuals to request their own health information under HIPAA, and specifically 45 CFR 164.524. And it is a little bit easier in that respect, and there's more cover for entities to provide this information to patients as they're being discharged based on oral requests without having to sign a release or sign a request for their own medical records under that change that was implemented as part of the HITECH Act. So I think that is something that requires some additional level of mindfulness. If there's normally a policy that has been implemented that requires patients to sign for receipt or request of their medical records, in this situation it might have to be abrogated or limited in some way. The other concern, in addition to the EMTALA concerns that you raised, home health agencies do have the right to discharge patients that are disruptive or problematic or not conforming to the standards of the HHA, and that is under Section 42 CFR 44.50. And there's provisions for discharging that patient if they're going to be disruptive to other patients or to the operation of the HHA. But there are also limitations on doing so that are imposed by this new discharge planning rule. So it's not as simple as just discharging a patient because they're failing to comply with the requirements or because they are causing issues for other patients. Even if that patient is going to be discharged, even if it's on an expedited basis because of the harm that they potentially pose to the integrity of the program, to its administration, and ultimately to other patients, there's still the need to integrate caregivers and work with the patient, which might be very difficult in this circumstance if they're being discharged unwillingly, to make sure that these standards and obligations are met. So that is something that I see the need for HHAs to plan around and integrate into their existing policies and procedures so that they're compliant with the new rule while still maintaining successful operations and discipline among their patients. And then there's some other considerations that we had talked about as well, such as state documentation requirements that might be more restrictive than the IMPACT Act, and the subsequent enacted COP provisions, whether for hospitals, critical access hospitals, or for home health. And Lisa, I know you spoke earlier about the very urgent deadline for the kind of compliance issues that are going to crop up because of the date of compliance with these rules being November 29th, 2019. Do you have any comments about best practices for compliance and how to quickly make these changes based on your experience working in the hospital setting?
Certainly. I think what facilities need to remain mindful of is that if you don't already have those policies and procedures in place, certainly critical access hospitals, it's unlikely that you have policies that are in place that contemplate your discharge planning process, especially not with specific requirements under this rule. So certainly get started on getting some policies in place to be able to guide those procedures, because that's certainly something that will be required before the November 29th deadline. And then as far as hospitals, just revisions to those policies that are currently existing to make sure that they take into effect some of the new requirements under the rules, especially those to be patient-centered on patient goals and treatment preferences.
And I see that we have some questions that were raised in the sidebar as well. Just want to see if we can go through some of those quickly. We talked a bit about EMTALA. We talked about some of these other considerations. I think the only one that we haven't discussed already is the issue of making sure that there's patient access and inclusivity that's required under Section 1557 of the ACA. and the rules that were adopted based on that. So at least I know that it was covered in one of your earlier slides to make sure there's an inclusiveness about language and other cultural sensitivities. Is there anything that you've seen come up that's particularly salient to that for hospitals and the critical access setting?
Well, I think there's a few different, and in fact, I don't think I covered it. I think it's in a slide that might be coming up. I remember there was a slide, but it was definitely the commenters suggested that facilities need to remain mindful of effective communication for those individuals with disability and meaningful access for individuals that have English as a second language. So definitely want to be mindful when implementing policies and processes for patients that maybe don't fit the typical mold and will require additional resources to be able to fully comply and fully understand the discharge process and implications of post-acute care outside of the hospital. I think there's also reference to the cultural and linguistically, and I'm going to totally screw it up without my notes in front of me, but the services, something that's provided by CMS as far as resources to ensure cultural sensitivity when communicating with various populations.
And CMS has been very good about providing those resources. I remember when the rule began to be implemented in 2016, a lot of providers had questions about how they were going to come up with signage and the number of languages that were contemplated and required by the rule, but CMS was very forthcoming with resources for that, and they're available throughout the CMS website, and it's something that we can help people navigate and find if the need requires. So there's a question from in the sidebar. It reads, as a small critical access hospital that refers patients to larger hospitals 200 or more miles away, the surveys show no info about your critical access hospital because the numbers are too small and you do long-term care under the critical access hospital umbrella. So you don't have a nursing home quality measures and it's not being reported under that rubric. How or what are the larger facilities supposed to provide patients information about our facility, and how will either the patients or the facility know that we have nearly no community-based or non-healthcare services? In terms of what the data collects, I think that's important because there are, as we know, data reporting requirements under the IMPACT Act, but like statistics, what the data doesn't reveal or doesn't report is more relevant in certain circumstances than what it does provide. To the extent that this isn't reported to the government and not something that's going to show up in the links that we indicate at the end of the slideshow, I think it's something that can be addressed by providing information to the other larger facilities or to the other hospitals in order to inform them about the services that you do and don't offer, and it's almost more of a marketing function than a government reporting function. Lisa, what are your thoughts on that?
Yeah, I agree. I think it's the requirement is for reasonable efforts. So it's not something that you have to go outside the scope of what would ordinarily be available as far as what you're providing, what you're communicating. And of course, there's additional requirements that are going to be forthcoming with a more implementation of the IMPACT Act. So I think that's something that's kind of a stay tuned as far as what those requirements might be in the future.
And then to the question that just came in about if there's only one possibility in the geographical area for home health or a skilled nursing facility, do you still need to provide quality and resource data? Yes. The reading of the regulation requires everything within the geographic data, the geographic location specified by the patient for LTCH, IRF, and SNF needs to be provided. Even if there's just one, the obligation is to provide the information about everything that is there. So the fact that the sample size is just one, it wouldn't matter if it was one, it wouldn't matter if it was 100. All that information needs to be provided. The only slight deviance from that is for home health, the geographic area is specified by the agency rather than by the patient because the home health agency only services a specified area that may or may not be within the area that the patient needs services. So that's the only slight wrinkle to it, but regardless of number of participants, that's the information that needs to be provided.
Right, and let me piggyback on that one as well. For critical access hospitals, it is expected that you contemplate within your discharge planning processes what steps you're going to take when there are not resources available. So is it going to be expand the geographic area, to provide resources for patients outside the area, so that especially if there's not a particular post-acute care provider in the area, like what are your other options, what other options are available to that patient. It doesn't have to be an option that the patient is all that excited about. And I think one of the references was, do we provide them, they don't want a facility that's rated a 2. Document that in the medical record as to why you didn't provide them information about facilities that were rated at 2 and what you did, what steps you took to provide them with alternatives based upon their imposed limitation.
So our next slide, I think that covers all of the questions. Within the slideshow, there are links to the sources of information that are gathered by CMS that compare SNFs, LTCHs, IRFs, and HHAs, so that there will be more information that can be used to provide these lists and to provide the data that's required by the regulations to provide to patients so that they can make informed decisions with their caregivers. And then the other question that came in is, now that we are required to provide a list for the IRF LTCH in the geographic area, does this mean that the patient choice is now required? Well, I think the goal is to facilitate patient choice along with working with the caregivers. It's something where financial interests obviously have to be disclosed, but in terms of allowing patient choice, to some extent that's driven by what kind of payers that they have, and that's why there's that requirement for managed care recipients and enrollees to be informed by the hospitals of the necessity of checking whether that is going to be in their network. Patient choice was always the goal. Whether that's functionally achievable is a different question. So the goal here is to achieve and facilitate patient choice in terms of whether the patient can actually make a choice or it's a kind of a false choice based on what their coverage allows. That is going to be a practical and case-by-case scenario. Lisa, I'm sure you've seen a lot of this in the hospital setting as well.
Yeah, correct. Yeah, I echo everything you said.
And then finally, there are some resources at the end. There are links to the CMS press release announcing the implementation of the final rule and the final rule itself. We have copies of that if anybody is interested in receiving them. Again, the important thing about this rule, it's not necessarily anything that wasn't foreseen, and this is something that has been in the pipeline for several years at this point. But what's very interesting about it are, within the comments, the things that CMS declined to codify as final rules at this point in time, and that might be coming down the line at some point in terms of increased reporting burdens and more specificity about what needs to be within these discharge plans in the future, whether for hospitals, critical access hospitals, or for home health, and trying to reconcile any new obligations for home health agencies with the existing requirements, which in some ways were more extensive than what the hospitals required for keeping extensive information, providing it to the patient upon discharge. And in some ways, I think that the new regulations of the IMPACT Act and the changes that were made to the existing rules brought the home health agencies and the hospitals a little closer together with respect to their discharge planning and put them on parity, not just with respect to the information that needs to be provided about post-acute care settings, but also just about the information that needs to be gathered and how it needs to be shared with subsequent caregivers.
And I think it's really, beneficial to point out that CMS was very mindful of the burden that their proposed rules were going to impose on all of these facility types, and really did scale back their proposed rules to a much more manageable discharge planning final rule. And so I think that is in large part due to the nature of the comments that they received and were forced to respond to, acknowledging the burden that their very prescriptive proposed rule would impose. So it's favorable. Go ahead.
No, I think that they will gradually be rolled out just in a piecemeal fashion, depending on what needs arise in the marketplace, especially as for the population that is going to need more intense care and more hospitalization continues to age and require more of these services. I think that we'll see some of these incrementally be implemented. So it's worth being mindful of their existence now and giving some thought on a rainy day about how these could be implemented. But fortunately, the obligations are not more extensive than those that were imposed within the final rule. But it still comes at a cost of, over $10 million for the hospitals, closer to $20 million for the hospitals, and over $10 million for home health agencies.
Okay, well, it looks like we're at time. So thank you all for joining us. And again, if you have any questions, please reach out either at this point, please reach out by email, and we will follow up with some of those questions. If we weren't able to get to them, we will follow up with you after this webinar. So thank you so much for joining us today.
Thank you for your time.